8 is not the fourth. So Articles 233 to 237. So Article 233, refusal of assistance. So the penalty of arrest mayor in its review period, 2 months and 1 week to 4 months. Suppression correctional in its minimum period, 6 months and 1 week to 2 years and 4 months. Perpetual special qualification, or it is a lifetime restriction that permanently bans or bars a person from holding a specific public office or employment, or even exercising specific rights like the right to vote and the right to be elected. And the fine not exceeding 1,000 pesos shall be imposed upon a public officer who, upon demand from competent authority, shall fail to lend his cooperation towards the administration of justice or the public service. So if the failure shall result in serious damage to the public interest or the third party, or otherwise arresto mayor in its minimum and maximum periods, and a fine not exceeding 500 pesos shall be imposed. So this article punishes the public officer who fails to cooperate with competent authorities in the administration of justice or public service, causing harm. So there are 3 elements. First is that the offender is a public officer. Second, that the competent authority demands that the offender that he lends his cooperation towards the administration of justice or other public service. So, the public officer must have the power to assist within the scope sa iyahang power. Kung namin na-request sa iyaha. So, it should be upon the demand from competent authority. So, kinahanglan nga from the demand of competent authority. So, if ang chief of police kay naka-receive of private subpoena from a private party issued by the fiscal with a request to serve in person to be witness, then ang chief of police ikuan siya ni-refuse, maliciously refuse to do so, then hindi siya liable aning article. Kaya since dapat ang subpoena must be properly transmitted through official legal channels to trigger their duty to serve it. For example, court or superior. Then number 3, that the offender fails to do so maliciously. So, wala siya valid na reason na dilian ang usap sa request for assistance. So, for example, si Pedro, girape ni si Julia. Then, si Police Officer Juan, siya ang ginagawa ng investigation. So, nasampahan o kaso si Pedro. So, si Juan na ma-receive of Estrebella para mag-testify sa court regarding sa investigation. But Officer Juan maliciously refused, and he said na di na daw niya testimony since na daw witness. If Officer Juan hindi siya ma-appear sa court, then na-violate niya ang article. Because the factors that dapat i-consider para ang isang witness if credible ba siya. So next is the refusal to discharge elective office. So Article 234. So the penalty of arrest of mayor, 1 month and 1 week to 6 months, or a fine not exceeding 1,000 pesos per vote shall be imposed upon any person who, having been elected by a popular election to a public office, shall refuse without legal motive to be sworn in to discharge the duties of the said office. Now there are 3 elements. First is that the offender is elected by a popular election to a public office. So na-elect ang officer sa public election sa popular election. For example, senator, congressman, governor, vice governor, etc. So dapat naging public officer siya through a popular election. Second is that he refuses to be sworn in or to discharge duties of the said office. So after there is no legal motive for such refusal to resort to the discharge the duties. So wala siya valid na reason para refuse. For example, hindi kaya sa health or iyang doctor advice in care nga hindi niya kaya or hindi siya mag-bed rest. Another valid example is or reason is kanang nag-visit siya after niya madaog. So, shall refuse without legal motive. So, if underage man or otherwise disqualified, then iyang refusal to sworn or to discharge the duties of the office is justified na. So, the reason why refusal to discharge the office is punished because once an individual is elected to an office, then by the people, then the discharge of duties of his office become a matter of duty. Hindi siya right, but duty. So, important, an article to the report na dapat ito is, kani siyang article is, ka-penalize lang siya to discharge duties of unelected office lang. But, refusal to discharge the duties of an appointed office is not covered by the article. For example, or filed the appointment rather than a popular election. For example, ang president, i-appoint ka as Secretary of Health, then i-refuse ka, then you are not liable sa ating article. Then, Article 235, maltreatment of prisoners. So, the penalty of prison correctional is period 2 years, 4 months, 1 week, 4 years, and 2 months. Prison mayor in its period 6 years and 1 week, 2 years. So, in addition to this liability for physical injuries or damage caused, shall be imposed upon any public officer or employee who shall overdo himself in the correction or handling of prisoner or detention prisoner under the charge by the imposition of punishment not authorized by the regulation or by inflicting such punishment in a cruel and illegal manner. And if the purpose of the maltreatment is to extort confession or to obtain some information about the prisoner, the offender shall be punished by prison mayor in its minimum period, which is 6 years and 1 year, and temporary special disqualification. So, mali siya is, penalty ni siya nga nag-restrict sa person sa iyang right to specific public office or practice certain professions. And ang fine not exceeding 6,000 pesos in addition to his liability for physical injuries or damage caused. So, elements. The offender is a public officer or employee. So, the public officer must have an actual charge sa prisoner to hold him liable for the maltreatment of the prisoner. That he is under charge of the prisoner or the detention prisoner. That he maltreats such prisoner in either the following manners. A. By overdoing himself in the correction or handling of prisoner or detention prisoner under discharge. So, such as depriving the prisoner of his right to conjugal visit, for example, or visitation right, or hindi siya maka-honor for 1 month or 1 week. 1. By imposition of punishment not authorized by the regulation. So, for example, hindi siya once sa iyang right to conjugal visit or visitation right, or by inflicting such punishment those that are authorized in a civil humiliating manner. For example, ipaligpit siya sa isa selda, pero if it's 24 hours, minimum of 48 hours. B. By maltreating such prisoner to extort a confession or to obtain some information from the prisoner. So the maltreatment must relate to the correction of handling the prisoner. Must be for the purpose of extorting confession or to obtain some information from the prisoner. For example, an people versus Javier. So, if a jailer inflicted physical injuries on the prisoner because of cash lang against the prisoner, then the jailer is dili siya liable ani the article. Kay since dapat for the purpose of restoring confession or obtaining satisfaction. So, offended party must be a convict or detention prisoner. So, the offended party is either a convict by final judgment or natulan na supporting for a specific crime or a detention prisoner. So, to be a detention prisoner, the person arrested must be placed in jail even for a short period of time. For example, an people versus body. So, ang isang person is na suspected siya kung having committed for a certain crime. Then, i-taking, tala siya sa cemetery and i-maltreat siya there sa policeman. So since wala pa siya na-book sa office of the police and placed in jail, besides a short period of time, then ang detention prisoner he is not a detention prisoner. Therefore, ang policeman kay dili siya liable ani ka article. The offender may also be liable for physical injuries or damage. So, the offender is also liable for physical injuries or damage caused if any is caused by violating the prisoner. So, kani article is kung matingala mo, makaingon mo of offense crime siya or one act sa to crime, pero dili siya mahulog sa complex crime because specify man din sa article na in addition lang ang physical injury. So kung malpit ako sa mga prisoner o detainer, then ang cause of physical injuries in addition lang ang physical injuries. Then section 2, anticipation, prolongation, and abandonment of duties and power of public office. So Article 236, anticipation of duties of a public office. So any person who shall assume the performance of the duties and powers of any public officer or employment without first being working or having given the bond required by law shall be suspended from such office, employment, until he shall be paid by the respective formalities and shall be fined from 200 to 500 pesos. Some elements are that the offender is entitled to hold a public office or employment either by election or pending. That the law requires that he should first be working. Ito yung mga public officer na pagdalaog, wala pa lang yan ba sworn in or should first give a ban. Then, that he assumes the performance of the duties and powers of such office. That he has not taken his oath of office or given the ban required by law. For example, if you have appointment papers on your as you won your election, it is not indication na dapat mo start na assuming sa iyong responsibility. Dapat take ka off or muhatag mo ang ban. So, ang ban is isang kumpany na siya or legal insurance policy that a public officer must submit before starting their job. So, ang purpose sa ng ban is to act as security deposit or for government. So, for example, kung ma-apply ka to PNP, GFP, or PFP, it is not enough na may appointment papers for you to be authorized to work. So pag-receive mo ang appointment paper, itrabaho dahil ka, then liable ka ani ng article. So dapat ka mag-take oath kung sa or mahatag ng ban. So ang ban is usually required na siya for officer na handle of kanang money, for example, treasurers. Then Article 237. that he continues to exercise the duties and powers of such office. So under the civil sentence rules and mandatory retirement age is 65. So kung 65 na ka, then required na ka, dapat ka function sa mga office. Otherwise, kaya mo ka ani article. So if uniform personnel naman ka is by the age of 56, wala siya ang promotory retirement. So at the age of 56, wala naman ka sa iyong mga service. Then yung nakapagkate, kaya mo ka ani